People often ask me, what happens if my loved one dies without a trust? And what I explain is, then you have to petition the court to be appointed an administrator of the estate. This is when they have assets that need to be dispersed to their beneficiaries, but there's no trust to move those assets to those beneficiaries. And even with a will, you may need to petition the court to be appointed as administrator or executor so that you can make those decisions and move those assets. Keep in mind, a will doesn't keep you out of probate court. It just gives the court instructions for how to disperse your assets. To be appointed administrator, there's two really important concepts. These are steps you have to take: notice and publication. Notice is required to all interested parties, and if you fail to notice someone who's a required party, then you're going to be in big trouble. It could be that the court thinks you did that intentionally, or you may not get very far and you have to re-notice, which can be expensive and timely. Second, publication has to be completed, and that has its own steps and also time restraints, and that can be costly if you do it wrong. When you get to court, and the court is considering whether or not appointing you as administrator, the judge might consider whether or not they want to order a bond be posted. The situation is different for each case. However, bonds can be required and they have to be posted with the clerk's office before you get your letters of administration. Once you get your letters of administration, the type of letters is really significant. Do you have full authority as administrator, or do you have limited authority? That's going to be impacting your ability to sell real property, if there's real property that needs to be sold, and to invest and move assets. Limited authority is going to require more court supervision, while full authority gives you more freedom, but keep in mind, you're a fiduciary. You have a responsibility to manage the estate assets, to keep them separate from all your personal assets. You've got to inventory those assets, and you need to have those appraised. You do that by reporting all assets to the probate referee, and this information in turn is going to be reported to the court. There's a 4-month creditor period that runs. As soon as you get your letters of administration, all known creditors will have to be noticed of the administration of the estate, and on top of that, creditors will either seek out a claim against the estate, or they'll notify you or the court that they have a claim. The administrator has to either contest those creditor claims, or you have to pay them. Finally, administrators will file a final petition for a final account and disbursement, and that's to be paid for the administrator fees, to have all costs of administration paid, and for all beneficiaries to inherit whatever assets they're going to inherit. If you have questions with any of this process, don't hesitate to give us a call here at David Greiner Law Corp. Thank you.